The filings continue in the challenge against Illinois' gun and magazine ban. Good morning, it's Illinois in Focus Daily. I'm Greg Bishop, and we're here each and every weekday morning for Illinois in Focus. Get the podcast where you get podcasts to catch the entire show. But don't forget, you can also join us live in the chat room with a lively bunch each and every weekday morning here on YouTube, so check that out. All right, so we've been tracking the state's gun ban since it was enacted January of 23. Shortly thereafter, lawsuits in the state court and in federal court were filed. The state court lawsuits resulted in thousands of restraining orders against the state from enacting the law on individuals and gun stores, but ultimately all of that went away after the challenge went all the way to the Illinois Supreme Court, and we can all remember that saga. But what has legs and continues on is the challenge in federal court, in particular out of the Southern District of Illinois, where 4 plaintiffs groups joined together by Judge Steve McGlynn, heard a 4-day bench trial on the merits and produced a record. Ultimately, the district judge deciding that the state law banning certain semi-automatic firearms and magazines over certain capacity was unconstitutional. But he put a stay on his order pending appeal. The state did appeal. The appeals courts continued a stay on McGlynn's order that it's unconstitutional and a permanent injunction against the law. So again, the law is still in effect. And I did see an interesting share on X because Dana Lash shared a story about one of the measures we've been tracking, Senate Bill 8, and how that is advancing at the State House, and that's the safe gun storage bill. But somebody asked Grok, that's X's artificial intelligence. Let me just pull this up can you explain the state of Illinois like a 5-year-old why this is unconstitutional? And it was about, locking up firearms. Grok, again, AI, artificial intelligence from X, says, hey, imagine the Constitution like a rule book for the country. One rule, called the Second Amendment, says people can have guns to protect themselves. Illinois made a law saying some guns and big bullet holders aren't allowed. The judge said this law breaks the rules because those guns are used by lots of people for safety, but others say the law keeps everyone safer by stopping dangerous guns. Courts are still arguing, so the law is still on while they figure it out. It's like when grown-ups disagree on what's fair. So always fascinating to see what artificial intelligence can do to explain things like you're a 5-year-old. But regardless, the case continues. As we saw last week, the state had to file their brief responding to the district judge saying that it was unconstitutional. And we found that the state said, unprecedented societal concerns, new technology for these firearms, allowing for rapid firing and the expanded magazines, large capacity magazines, as the state calls them. Allow for all of this. So that was the chief kind of, also 50 cals and expanded magazines aren't arms, they're accoutrements, the state argues. But we have a brief, what's considered an amicus brief that was filed yesterday. And this is a friend of the court. That's essentially what amicus means. And it's from March for Our Lives. Let's go ahead and pull this up so we can just kind of see what they're going after. So the brief was filed yesterday in federal court. Got all of the stuff saying, hey, this is an amicus brief and these are the attorneys. And we'll go through the table of contents. I'm not going to read all 34 pages here, but they ultimately say the covered weapons are not arms for purposes of the Second Amendment. Like M16 machine guns, the covered weapons are not arms under the 2A. The legislature reasonably disagreed with impartial distinctions between M16s and covered weapons identified by the district court. The district court misapplied this court's precedent to conclude that the covered weapons are in common use and therefore are not military grade. And that's what I think is important to note here. This record that was set by the district court, 4 days worth of experts, former military, trainers, even gunsmiths, and technicians talking about metallurgy and the difference between, semi-automatic and full auto and burst, and the use of full auto and burst in the military, and the different types of firearms that the military has and contracts to get. They don't get semi-automatic firearms. They get the military-grade firearms. So this record really lays it out because the appeals court on preliminary grounds in 2023, they ultimately said that, they feel that there's a too close of a relationship between military-grade firearms and the semi-automatic firearms that were banned by the Protect Illinois Communities Act, the gun and magazine ban. So that's why the district court on the merits, after preliminary issues were dealt with by the appeals court, it went back to the district court, and on the merits, the district court addressed and had the litigants lay out their experts to discuss the difference between military and civilian firearms. So that's really, I think, at least my understanding of the appeals court on preliminary grounds, their position, and how the district court addressed that. But let's go back to the contents here from March for Our Lives in their amicus brief. So they said that the district court misapplied the appeals court's precedent to conclude that the covered weapons are in common use and therefore not military grade. The district court's conclusion that the covered weapons are dual use weapons under Bevis was legal error. They say even if the covered weapons are arms under the Second Amendment, the Protect Illinois Communities Act is constitutional because it is consistent with the history and tradition of firearms regulation in this country. They say that it satisfies Bruin's how requirements, Bruin's why requirements, and they say that the district court erred in holding the Protect Illinois Communities Act is not relevantly similar to the country's history and tradition of firearms regulations. And then you can see there it goes through 10 pages of the Highland Park July 4th, 2022 mass shooting, which we just had resolution there from the guilty party, Robert Cremo III, ultimately changing his plea, going guilty, and getting a sentence. So that's the latest in the Barnett case. Obviously, the plaintiffs are going to respond to the state early next month. We'll get that brief, and then the state will have a time to reply there, and then we should get some kind of oral argument date for the Seventh Circuit U.S. Court of Appeals. So that's the latest twists and turns in that particular case. But something else firearms related. Late last week, there was a conversation about a measure at the State House that's already passed the Senate, and this would ultimately impact explosives and permitting and also consumer fireworks. At least that's what it's listed as. So let's go check this out. Senate Bill 2431. This passed the Senate. It's now in the House, and it's on second reading. Takes 3 readings in each chamber. So it passed the Senate. Let's see here. Going through the status of the bill, last month, April 9th, passed 39-16. All right, and that is with Senate Floor Amendment number 2. Looks like that's the only one that went through. So then you go back up here and you look at the synopsis, and it talks about it amends the Illinois Explosives Act, makes changes to defined terms, provides that no person shall acquire, possess, use, transfer, or dispose of explosive materials unless the person has obtained a valid Illinois individual explosives license issued by the Department of Natural Resources, except as provided in the Act. In provisions concerning qualifications for licensure, provides that no person shall qualify to hold a license who is an unlawful user or addicted to alcohol or any controlled substance, or has been adjudicated a person with mental disability as defined by the Firearms Owners Identification Card Act, or the person's FOID card is suspended or revoked. Provides that upon receipt of a second revocation of an explosives license, the person shall no longer be eligible to apply for an Illinois individual explosives license. So essentially it sets up an explosives license. And we look at Senate Floor Amendment 2, which passed. It says removes language providing that no person may possess or store a firework cake designed for consumer use that exceeds 500 grams in total explosive commercial composition. So there was a House amendment filed on this. Looks like House Amendment 1 was adopted. So this is going to, come back up on the House floor as amended, and it'll have to go back to the Senate for concurrence. So you understand how that works, right? Have to get out the old Schoolhouse Rocks, I'm just a bill. But House Amendment 1 replaces everything after the clause, and it reinserts different provisions of the engrossed bill. But here's a little bit back and forth in the House Judiciary Committee last week with State Representative Patrick Windhorst asking questions about what's in particular impacting the FOID card aspect of all of this.
It looks like it adds under Section 2005 A5 is an unlawful user of or addicted to. We add alcohol to or any controlled substance. And then 6, has been adjudicated a person with a mental disability as defined under Section 1.1 of the Firearm Owners Identification Act, or the person's FOID card is suspended or revoked. And the question I had was, I guess first, with regard to alcohol, why that was added, if that has been an issue that has occurred, and then number 2, the FOID card change.
And then you have the Department of Natural Resources attorney, Amy Oakes, explaining some of the aspects of why they added that language in there.
Those things are consistent with the federal laws that we also operate our program under.
And there is no federal FOID card requirement. So the part about the FOID card, why was that added?
That was added for consistency with the FOID regulations, as the two go hand in hand. If a FOID card is revoked, there's a notification that goes out to a explosives license holder that puts a hold on their ability to apply for that license while that FOID card revocation is pending.
So just a little bit more explanation there of what this is. Here's the sponsor in the House, Jay Hoffman, Democrat from Swansea, saying what the real purpose of this measure is and why they need to get this across the finish line.
What this does is it clarifies many of the provisions of the Act. It also ensures that the provisions regarding proper storage, proper transportation are followed, and clears up some of misconceptions regarding the Act. There had been some questions about what does this apply to. These explosives can be used for demolition, they can be used for mining or many other purposes. However, they are very dangerous, and individuals are licensed in order to be able to not only store them, but to utilize them and to transport them.
So just again, this is, the legislative process at work here. And that's just one particular bill that, involves possible changes to or updates wrapping other laws into the FOID Card Act. So watching that closely, watching Senate Bill 8 closely. Senate Bill 8 still in the House Gun Violence Prevention Committee. They meet today. It's going to be a busy day today. This is our team with Blue Room Stream. Just some of the events that we're live streaming. Now, Blue Room Stream is a subscription service. It's a lot of work involved in getting these live feeds out, and that's kind of some of the video you see here on the air with Illinois in Focus Daily. But we're going to be busy today. There's no question. So if you look, you've got just gobs of news conferences, the Joint Committee on Administrative Rules meeting, and so on. But you also have the House Gun Violence Prevention Committee with House Joint Resolution 26. What is House Joint Resolution 26? Let's go to ilga.gov, House Joint Resolution 26. Let's see if we can pull this up. End Gun Violence Task Force. So they want to create the End Gun Violence in Disproportionately Impacted Areas Task Force to study, analyze data, make recommendations, develop policy proposals. There's an amendment, deletes everything and reinserts, just makes it the End Gun Violence in Disproportionately Impacted Areas Task Force, makes it the director of the Department of Commerce and Economic Opportunity an ex officio, non-voting advisory member. So they would investigate gun violence in certain areas. So that's going to be discussed in the House Gun Violence Prevention Committee. Curious, though, if they may also bring up Senate Bill 8 or when that is going to advance out of committee before it gets voted on in the House. We'll be watching all of this. It's going to be a busy couple of weeks here with Illinois in Focus Daily. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning as we break down the news impacting you here in the land of Lincoln. I'm Greg Bishop, and you can catch this show live or you can get the podcast. Just search Illinois in Focus Daily.